Tort law. Gotta love tort law. Anyone looking to go to law school, maybe did go to law school, good old tort law. Let's talk about this. Let's understand what it is. Make sure you're familiar with it. Tort law is a branch of civil law that deals with harm caused to individuals or property as a result of someone else's actions or omissions. A tort, what is a tort? A tort is a civil wrong that can result in a legal liability for the person who caused the harm. Pretty simple in its definition, but we'll obviously run through lots of implications and examples and more criteria. Tort law applies to a principal and agent relationship when an agent acting on the behalf of the principal causes harm to a third party. One classic example I love is, let's say you are a driver of an ice cream truck. You work for a mega ice cream truck conglomerate that owns all the ice cream trucks around. You're hired as either an employee or an independent contractor to drive the trucks. And if you hit someone with that car, who's liable? We'll talk about that in all different scenarios there. Also, yeah, delivery. I mean, if you're an independent contractor or an employee, you're driving trucks for Amazon, FedEx, something like that, applies there as well. I just like the ice cream truck one because it's a little more fun, and I do love me some ice cream. Now, tort law deals with harm caused to individuals or property as a result of someone else's actions or omissions. Just getting you familiar. We're going to keep hitting the main points. Make sure you're familiar here. Torts are civil wrongs that can result in a legal liability for the person who caused the harm. The principle of respondeat superior, we'll see this a bunch, and we have the definition of it. This is a good old Latin, keeps popping up, applies in tort law, which means that the employer or principal is held liable for the tortious acts of the employee or agent if the employee or agent is acting within the scope of their employment or agency relationship. Pretty much with the ice cream truck, if I'm driving the ice cream truck on duty, I'm on hours. On duty. I am active duty serving ice cream. So if I'm driving my ice cream truck during my normal hours, driving to where I'm supposed to sell the ice cream, and I hit someone, that's generally going to fall under the liability of the employer. Now, if I was driving recklessly, breaking the speed limit, drunk, something like that, it will fall on me. If I'm driving this outside of the normal hours of business and I hit someone, that's on me. So those are just examples of what we see. It really depends on, if you are following the employer's rules and regulations and what you're supposed to be doing within the scope of your job to the letter of the law, then the employer is at fault. If you, pretty much for the purpose of the exam, if you do one thing to break sort of what you should be doing, then you are going to be at fault. Now, in tort law, the injured party may be entitled to damages, which is monetary compensation for the harm caused. Some common types of torts include negligence, intentional torts, and strict liability. We'll look through these to find them. Negligence, it's a failure to use reasonable care that results in a harm to another person or property. If I'm just driving the car and I look away or I pick my phone, that would probably be negligence. Intentional torts are actions taken with the intent to cause harm, such as assault or defamation. If I go around and start defaming someone, I start spewing some lies about them, that would be an intentional tort. And then strict liability. This applies in cases where the harm was caused by an inherently dangerous activity or product, regardless of fault or intent. This could be something where you're selling something that is a toaster that has a 65% chance of exploding. I mean, that would probably fall there for sure. Let's see examples. We love examples because this is what you may see on the exam. Well, when the agent acts on behalf of the principal may be held liable for any harm caused by the agent's actions. For example, let's say that John owns a store and John hires Sally as his employee to manage the store. John's got other stores to manage, other things to do. Sally is acting as John's agent when she's working at the store. Now, if she goes after hours and gets drunk and smashes in people's windows, obviously John did not hire her to do that. She's not doing that on company time. If Sally causes harm to a customer by leaving a slippery floor untreated, the age-old example of the slippery floor, John may be held liable for the customer's injuries as the principal. Just you may think, hey, that's unfair. If John wasn't there, and why isn't Sally liable? If that was even part of her job description, is to make sure she cleans up the floors and puts the sign out that it's a wet floor. Well, make sure you hire competent people who follow the rules. That's kind of how the law views it. Hey, I'm not the one who makes the law. I don't make the rules. I don't make the law. I don't do anything here. I just kind of communicate them to you. This is because Sally was acting within the scope of her employment as John's agent at the time of the incident. Now, again, like if John explicitly in the contract says something such as, Sally, you are going to put out a wet floor sign whenever you wipe the floors up or there's a spill or something. I mean, is that going to be further disputed in the courts? Probably. But for the purposes of the exam, if something like this is going to be John's fault. Another example is when a real estate agent acts as agent for a homeowner trying to sell their house. If the agent provides false information about the condition of the house to a potential buyer, and the buyer suffers financial harm as a result, the homeowner may be held liable for the agent's actions. And right here, this is kind of what I was saying before. You may be thinking this sounds like the principal's getting the short end of the stick. Well, if the principal wants to avoid liability, he or she should train the agent, trust the agent, and if after all attempts at prevention of harm fail, the principal can take legal action against the agent after assuming liability for the initial tort. So this would be, and just going back to this example, if let's say John walks into the store over the course of a month and 5 different times he finds that Sally did not put a wet floor sign and Sally's leaving messes all over the floor, still John will be liable. But John can then go into a court and say, hey, here's proof that I reprimanded her 5 different times. I put notices that Sally has not actually kept the floors clean and has not put wet floor signs up. So then John could take action against Sally. That would be how it works. Again, you might be thinking, John's getting the short end of the stick here, and kind of, but also that's just how the court systems work. I'm not here to argue if they work properly or not. Maybe they do. Maybe they don't. I don't know. I'm an accountant. I am not a tax. I'm not a law individual. We've got another example here, and good old delivery driver. Great example. A lot can happen out on those dangerous roads. Make sure you're driving safely whenever you are. A company hires a delivery driver agent who is transporting goods from their warehouse to various locations. Now, while on the job, the delivery driver causes an accident that injures a pedestrian. The pedestrian sues both the delivery driver and the company for the injuries sustained. Now, in real life, you can sue anyone. You can literally do whatever you want. You can sue whoever you want. However, who is actually getting sued for the purpose of the exam? That's something we'll talk about, right? Who should get sued, textbook-wise, in the actual basis of the law. Now, in this scenario, the delivery driver is considered an agent of the company and was acting within the scope of their employment when the accident occurred. That's just an inherent accident. Again, there are different levels to it, such as was the delivery driver speeding, were there other things? But generally speaking, if it was a straight accident, nothing else, it was just a act of God accident kind of thing, this is what we're talking about generally. Therefore, under the principle of vicarious liability, the company, the principal, would also be liable for any harm caused by the actions of the agent. The injured pedestrian can sue both the agent and the company for damages resulting from the accident. The company may also be held liable for any negligent hiring, training, or supervision of the agent, depending on the specific circumstances of the case. If this delivery driver had multiple speeding tickets and multiple accidents in his file from before he was hired, that's why we do background checks, try to see stuff like that, because then you generally would not assign this individual to drive a truck. You'd probably put them somewhere else within the company, right? Now let's talk more about principal liability under tort law. I mean, we're talking a lot of examples, a lot of different things. Make sure you're knowing all this. You're having a great time. We're becoming law experts ourselves. A principal is generally not liable for torts committed by an agent. This principle is rooted in the concept that a person should only be held responsible for their own actions or those they have direct control over. However, there are going to be exceptions here to this rule, particularly in the context of an employer-employee relationship. Now, when an employee is acting within the scope of their employment, the employer can be held liable for the employee's tortious actions. This is known as vicarious liability. We mentioned this prior, but let's talk about it even more. To determine whether an employer is liable for the actions of an employee, we are going to need to consider several factors. First, right to control the manner of performance, and we'll slowly transition into dealing with employees versus independent contractors, if that is something you're familiar with. That's a long-standing issue where we're dealing with our Uber drivers, Lyft drivers, employees, or are they independent contractors? That was a big legal argument back in the day. Also, just in general, what are the implications of that? There are a lot. We'll talk about that. We'll slowly transition over to that. So if that's something that sounds familiar based on what I'm saying here, yes, you are right, and we'll see that soon enough. Now, a key factor in establishing vicarious liability is the extent to which the employer has the right to control the manner in which the employee performs their duties. The more control the employer has, the more likely they will be held liable for the employee's actions. So as such, if we think about that, independent contractors, you're probably a lot less liable to have to face the courts if an independent contractor does something as compared to an employee. But it's very attractive to hire independent contractors instead of employees. Employee works full-time for the employer, uses employer tools, and is compensated on a time basis. These factors suggest a closer relationship between the employer and employee, making it more likely that the employer will be held vicariously liable for the employee's actions. Again, we will deal with that a lot more, dealing with independent contractor versus employee. Generally speaking, you are going to be a lot more liable for employee torts, whereas independent contractor torts, not as much. We got some situations in which employers will not be held liable. Let's see, actions outside the scope of normal job duties. Oh, yeah, if an employee goes and commits a crime on the weekend or when they're not at work, or even if they do it on work time, but they are on their lunch break driving over somewhere where they shouldn't be and committing a crime, that's not going to be something in the scope of normal job duties. Employers are not liable for actions taken by employees that fall outside the scope of their normal job duties. So, for example, if an employee commits a tort while running a personal errand during their lunch break, the employer would not be held responsible as this activity is outside the scope of the employee's normal job duties. Sit at your desk and eat your sandwich and shut up. Don't get into an accident on your lunch break. Oh man, I guess that's not a good takeaway from that. Intentional torts committed. Employers are generally not liable for intentional torts committed by their employees, such as assault or theft, especially if these actions are contrary to the employer's policies or instructions. I would hope that assault or theft are contrary to the employer's policies or instructions, but it's just another line in there as well. However, there are some exceptions to the rule. For instance, if the employee's intentional tort was committed in furtherance of the employer's interests or as a direct result of carrying out their job duties, the employer may still be held liable. A great example here is if you're repossessing something, you're working for a company, and you're trying to repossess something and you get in someone's face and you push them and they get hurt. That's definitely may fall on the employer, especially if the employer is promoting aggressive practices of repossessing cars and assets and bankruptcy. That would be something that may fall on the employer. Something like that. I'm not going to go too further. I don't want to get too dark, deal with these awful examples, but you get the idea. Got to keep my spirits up. This is definitely something that can bring me down. Law is very interesting. Got to love it, but also something where you could really get lost in it for sure. Well, let's get lost in a good way as we dive through more examples of tort law. Oh man, accidents. We've got some things that are going to bring us down, but we're going to have a positive attitude because you are going to pass your exam. You're going to earn your CPA license. You're going to go on your merry way and enjoy life. Now, in various scenarios involving a delivery company who is the principal and a truck driver who is the agent, liability for a tort against a third party may differ. Here, we're going to have some examples. Now, first, we've got the agent's negligence. If the truck driver who is the agent is negligent when performing duties, such as speeding or driving recklessly, they cause an accident, both the driver and the delivery owner could be held liable. This is due to that vicarious liability doctrine, which holds employers responsible for the negligent actions of their employees while acting within the scope of their employment. Generally, just car accidents, that's negligence. Generally speaking, that's what that would be determined to be. Obviously, if there's more things, like if you're constantly speeding or if you get into road rage, it could get a little more aggressive than that. But generally speaking, car accidents would be negligence. Agent's compliance and accidental damage. If the truck driver is fully compliant with their role, following all rules and regulations, but an accident still occurs, the principal may still be held liable under the vicarious liability doctrine. The specific circumstances of the accident and the applicable laws would determine the extent of the liability for each party. Basically, we don't have enough information to go off of here. There are a lot of ways that this could go. Principal's inadequate preparation. If the delivery company owner, the principal, fails to adequately train, supervise, or equip the truck driver who is the agent, and this failure contributes to an accident, the principal could be held directly liable for negligence. In this case, the principal's failure to properly prepare the agent led to the accident, making them responsible for the resulting damages. Next, we've got the agent's intentional tort. If the truck driver intentionally commits a tort while acting outside the scope of their employment, such as intentionally hitting a pedestrian, the driver would be primarily liable for the damages. Again, pretty much makes sense. I think that seems the most fair. The principal may avoid liability if they can show that the agent's actions were not related to their employment and were not foreseeable. Lastly, here we've got agent's independent contractor status. I've been hinting at that. We'll see that. Full slides about that as well. If the truck driver is classified as an independent contractor rather than an employee, the delivery company owner may not be held liable for the driver's actions under vicarious liability. In this case, the driver would be responsible for any damages caused while performing their duties. Now, ultimately, the specific circumstances of each situation and the applicable laws will determine the allocation of liability, but these are, generally speaking, how it all works. And as you practice questions, as you practice sims, you'll start to see, also the examples I've given you, you see the gist and the ideas, generally how the exam wants you to think of the law. And again, I do stand by what I say. The exam wants you to think a certain way, and that's fair. These laws can be interpreted many ways in the real world, but try to think as you go through and as you practice, how is the exam thinking? How are the exam writers trying to get me to understand the law? More examples. We are running through examples. We're practicing, making sure you're prepped and ready to go. We've got a real estate agent. Who is the agent? Oh no, shocker. The agent is the agent. They're hired by a homeowner who's the principal to sell their house. While showing the house to a potential buyer, the agent fails to warn them of a dangerous condition and the buyer is injured as a result. Maybe there is a floorboard where we know it is worn out and the agent doesn't put a sign up, doesn't warn anyone. The buyer walks through and steps through it and breaks their leg. The injured buyer sues both the real estate agent and the homeowner for the damages. Now, in this scenario, the real estate agent is acting as an agent of the homeowner and was acting within the scope of their employment when the accident occurred. Now, therefore, under the principle of vicarious liability, the homeowner may also be liable for any harm caused by the actions of the agent, depending on the specific circumstances of the case. The injured buyer can sue both the agent and the homeowner for damages resulting from the accident. Keep in mind that while questions may ask who the third party can sue, questions can also ask who would actually be liable, which can be different. So let's just read that again. Keep in mind that questions may ask who the third party can sue. So who can they sue, but who would actually be liable? So legally, they can sue either of these individuals, but who would actually be liable? That is maybe something different. Maybe something different, right? But additionally, while in the US these days you can sue anyone, you need to understand for the exam, who can a third party actually sue? That is different. I've had a lot of people throughout the exam, throughout tutoring, say, hey, I mean, I've seen someone sue for more than that. Well, per the exam, who can actually sue and for what reason? That is a difference we will be seeing here as well. Now, in general, it's the homeowner's asset, the homeowner's house. So the homeowner probably should have been the one to put that up. Again, we will be giving up a lot more examples, a lot more criteria within each of these. Now, examples of changes to the scenario that would affect liability. I love examples and I love questions where you change one thing, what happens? Because that's what could happen on the exam. You change one thing, what happens? Well, if the dangerous condition was not readily apparent and the real estate agent had no knowledge of it, the homeowner may not be held liable as the agent's failure to warn would not be considered within the scope of their employment. If the real estate agent was acting outside of their normal employment duties, such as using the property for personal use, there's being a little squatter there, the homeowner may not be held liable for any harm caused by the agent's actions. There will be a lot of criteria and a lot of points to break down with each scenario.
Hey there! Are you ready to not only pass your CPA exams, but truly understand and enjoy the material while studying? I know it seems impossible, right? Especially to enjoy the material? We'll do it together. Tap into the power of CPA.examprep.ai, where we've got personalized quizzes, multiple choice questions, memorization guides, flashcards, simulations, all tailored to your learning. Our adaptive study planning puts you on the fastest path to success and lifts you back up if you fall behind. Avoid wasting your precious time and money attempting an exam with a low chance of passing, because who wants that? We want to get you through this process as quick as possible. Our exam readiness prediction lets you walk in with confidence, knowing that you're prepared for success on exam day. Thankfully, there's no payment method needed to get started, so why don't you come join us? Visit cpa.examprep.ai and let's achieve your exam success together.